Here to talk about the renting and fair housing aspect for Oak Park is Cassandra Hurt of the Community Relations Department.
Thank you very much. Good afternoon, everybody, and thank you for coming back in for those that could stay a little longer. I am Cassandra Hurt, the Community Relations Coordinator for the Village of Oak Park. If you are familiar with the Community Relations Department, then you know that we enforce the village's fair housing, human rights ordinance, and the fair housing policy. Fair housing is important, it is crucial, it keeps you out of trouble, it keeps you out of the court system. How about that? Unless you just love to be in the court system? I don't think that's any of us. We don't want to get caught up in that. So we are located on the second floor. It's a two-person team, community relations. Cedric Melton is the director. I'm the coordinator. We're on the second floor at the west of the building, second floor. So you'll find us sitting there in our cushy psych offices, psych again. But we are up there. We take walk-ins, so if you're walking in and you have a question, just come in and ask us. You want to call us, give us a call. We'll take those phone calls as well. We also encourage block organizing, the community safety, and the multicultural training here. We mediate landlord and tenant disputes and neighbor disputes. Mediation is really good. It's in lieu of the court system. It saves money, but it also gives you the opportunity to talk about things and put options on the table before things go into another direction, right? Nobody wants, who has time for going to court and filing this and filing that? It takes money, it takes time away from what you're trying to do. So we do offer mediation services. Both Cedric and myself are certified through the Center for Conflict Resolution. All right, we provide residential training and community outreach. So we have things that are going on constantly, like if you've heard the dinner and dialogue and other types of activities to promote community, to promote unity, to promote diversity, to promote what it takes for us to improve or maintain the quality of life in the village of Oak Park. We also manage the village's graffiti deter and removal program. So we have a graffiti hotline. And yes, there are people that call the line religiously, and that's okay. So, but some of the graffiti we don't take down ourselves. If it's on the expressway, we'll call the Department of Transportation. If it's on the public buildings and public stuff like light poles, we'll call Public Works. If it's on your property, you have to get it down. You say, well, I don't know how to do that. I mean, I tried soap and water and Fabuloso. It doesn't work. Okay, well, we have a graffiti removal solution here. So if you need some, just come and ask us. We'll give it to you freely. All right, whether it's through us or if you happen to be talking to Jeff and his Department of Neighborhood Services, they have access to it as well. So if it's on your garages, just come and get it. Don't be like, oh, I don't know what to do, and oh, they keep doing stuff. Just take it down. And if you catch the people or you see them doing it, then hey, call the police. Call your RBO, say something about it. All right? But call the hotline number if you see it and you want to report it. We're okay with that. We do work to get that down. We try and have them take it down within 24 hours, but sometimes, Public Works is a little busy, and so they get to it. But if that means you call over and over, just call over and over. You're not bugging us. We'll take care of it. All right, and then in the Community Relations Department, those people that have discrimination complaints, they can be made right here in our department. We also will give instructions on, how to fill out and file in person or online, or what people need to do to start a complaint. Oh yeah, I have to do this. Psh. All right, I'll talk about mandatory lease provisions. So you've heard from our partners. Oh, they're gone now. I wish they had stayed a little longer in case you had some more questions, because we do tie into each other. So you've heard from the Oak Park Housing Authority. You heard from Mike Stewart in the Oak Park Regional Housing Center. You've heard the fire prevention. You've heard the rodent controls. All that is great. But we have people that's living in these properties, right? And there are things, again, that you need to know, that they need to know, that we need to do so that you can stay out of trouble, stay out of the courts, and we can have great lives here. So when you're doing a lease with your tenant coming in, and I'm talking about things that we get calls about. People call and say, we've had a couple of complaints, and I don't know, Jeff, if you heard that in yours, but a couple of people have called a few times to say, oh, they didn't tell me that about the parking in Oak Park. I got all these tickets I have to pay. I have to go and I have to do this, I have to do that. And all we can say is, you know what? They were supposed to tell you. Make sure you include the parking information in the leases, because that is key. We live in Oak Park, right? Parking has been an issue, and it will always be an issue. all right? People don't want to park 6, 7 blocks from home, they really don't. But they don't want to incur the tickets either because they want that money for the tickets and they're gonna get it. They'll just pile up and they get feed on down and then people come in, oh, I didn't know I had to pay. Can you waive this? Can you waive that? I can't waive it, but you can, adjudicate it, go and, complain about it. But,
No, you're too far away from the.
oh, I am. I'm sorry. I thought I was loud enough. Okay. Sorry. I get excited. I can do this. All right. So make sure you include the parking in this is a mandatory lease provision. All right. The lessee is responsible for providing the off-street if it's not provided by the lessor. I hate those words. Why don't they just say the tenant is responsible for this and the landlord is responsible for this? The landlord is responsible for letting them know about the parking issues and what can be done, if there is parking available or if it's not available, if there's a fee for it or if there's not a fee for it. You gotta say something. You have to provide that unit number. And I'm gonna tell you why all this is important. Because again, remember, we're trying to stay out of court and we're trying to stay good.
There is a handbook online for the village too.
Oh, yeah.
That describes that.
Oh, yeah, absolutely. Thank you so much. Have that unit number on that lease. There's a maximum occupancy. I get calls on that, like how many bodies can we have on the property? Hey, are my dogs considered a body too while we're in the property? Well, yeah, there is a space requirement. There is a max occupancy, and it is in the village code. If you don't know what a village code is, go to the Village of Oak Park's website. You're gonna scroll down to the bottom, and a little yellow word say village code. When you click on it, you're gonna get a split screen. It's gonna say codifiers, Sterling codifiers over here with all the different things, and that will be the information for whatever you click on. It'll be on the bigger picture. So you can do a little search. If you wanna search for pets, you can do that, or heat, or whatever it may be. So become familiar with the village code. If you are reading the code and you're not sure what it says, just call us. The expert on the code is sitting right here. You didn't want me to tell them? But Jeff is the expert on the code. All right, so if you have any questions about the code, Jeff is great with that. Make sure you have the full names and birth dates of all occupants, including the babies, the kids too. Have that on there. The name and phone number of the owner and management company, and whoever is available for 24 hours a day. We got a call just a few weeks ago that a young man who lives in a property where they is accessible, right? It's a supportive housing. He was locked out. His fob didn't work. And his fob didn't work all weekend. So he had to go and stay. He's an adult, so he had to stay with his parents for a few days. They were not happy about that. They couldn't understand why they couldn't get a hold. We can't get a hold of anybody. We can't get a hold of anybody. Well, it's true, they couldn't. Because they only had one person who would have been on staff. And for some reason, her phone number and information wasn't available. Well, that was grossly unfair to the young man. But we got it resolved on Monday in the afternoon. But the thing of it is, had there been other information, that could have gotten resolved earlier. All right, so make sure that information exists. Now, the reason you need these things is because when you go to court or you're trying to do some stuff, if you don't have it, the lease is void, right? Wow. You mean they lived here and I had this written agreement and I thought I was protected as an owner and now it's voided because I left off things that were essential and that could have been taken care of. All right, do that. Mandatory lease provisions.
I have a question. For the birthdays, you have to put that on the lease?
Well, it says name and phone number, full names and birth dates of all occupants. I say follow what it says in the code and in the letter, follow it. All right. Fair housing, Oak Park. What is fair housing? The right for all people to live wherever they choose and to be treated fairly and have access and enjoy the full use of their homes without unlawful discrimination, interference, coercion, threat, intimidation by owners, landlords, real estate agents, management companies, or intimidation by the other tenants. Anybody. All right, fair housing, that's what it is. And guess what? We have to abide by it. It keeps you safe. It keeps you out the court. It saves you money, it saves you time. All this ties into when you are leasing or when you are accepting a housing choice voucher, when you are looking for apartments, when you are listing your apartment with Oak Park Regional Housing Center, you have to make sure that you are maintaining the fair housing laws. It is the law. It's not my law. It is the law. Just a few fair housing facts to let you know it is real. Maybe it hasn't happened to any of us in here. Nobody's probably filed a complaint, but they file complaints all the time. Over 10,000 every year. People are charging, making charges for what? Discrimination, Discrimination in the terms and the conditions of the sales of rentals. I'll break it down a little bit more in a couple more slides. Their fouling housing discrimination is perpetuated by other elements like segregation, predatory lending, and gentrification. What's gentrification? I'm glad you asked, for those that don't know. It's really when you're changing the scope of the neighborhood and the people that are indigenous to the community are priced out the box, they can't come back. All right, you're changing the community. All right, those are considered discriminatory practices. You want to watch what you're doing. And the way to do that is to be fair across the board in all of your actions and all of your transactions. Use the same leads, use the same screening tools, do everything the same. You should have no problems with somebody saying, well, I didn't get it because I didn't get it because I had, or they gave it to them because they are. If you do everything the same across the board, you shouldn't have a problem. And I will say this, I'm not gonna say you shouldn't have a problem, take that back. You shouldn't have a problem for protecting yourself if a claim or something comes against you. Because when you have to prove what you've done, you can say, look, I've been consistent across the board, right? Consistency, be consistent, then you should be able to, stand a little stronger. All right, federal housing laws requires entities receiving federal funds, like the Village of Oak Park, we get federal funds, to affirmatively, further fair housing and promote integration. And for people, if you know of any developers, when people take land, like I'll just use the CHA as an example. When they tore those high rises down and they said, we're gonna redevelop this land and build all of these units for mixed income. Well, they had to allocate a certain percentage for subsidized housing, for low income, for other types of things, tax credits. So just keep that kind of thing in mind. So if you are in that kind of work and you are developing and you're using federal funds, be prepared to uphold the fair housing laws and to allocate so much, whatever you do in your business practices, what you do, but I'm just giving you a general idea. Any questions so far? No? Oh, very good. Let's talk about the protected classes in the Village of Oak Park. And this is really the state of Illinois, all right? All the ones that you see on the left and all the ones you see on the right. No, okay. All right, that was easy. But let me tell you this. In case you don't know, pregnancy was added to this list. For real? Yes. So a pregnant person coming to you, wanting to rent, and you're like, you're pregnant, you might fall and slip, and it's ice on the ground, blah, blah, blah. No, because that's a familial status now. So that is also, that person that's pregnant, pregnancy is a protected class in the Village of Oak Park now, in the state of Illinois. All right? Next, I keep forgetting with that. Now, we talked about protected classes, let's talk about the source of income protection. And I say these things because, again, people come from all over with different backgrounds, different socioeconomic backgrounds, different things going on up here that we can't really see, right? We don't know. But, you treat everybody fairly, you do everything the same way across the board until something else is discovered. But in Village of Oak Park, we have a protected category that was passed in December 2013. The source of income includes your wages. Well, how is that a protected class? Because I can make $24,000, somebody can make $124,000. But guess what? That doesn't mean I'm the rotten person that can't rent. Well, $24,000 is kind of low, but I'm just saying, but you get what I'm saying with that. Sources of income, alimony, child support, income derived from Social Security, SSI, SSDI. These are protected classes of income. Federal, state, and housing rental subsidies. The Housing Choice Voucher, AKA or FKA, Section 8 vouchers, is a source of income. So if you say, well, I don't want to rent to you because you have a voucher, you just set yourself up. How are you going to defend that? You said it. You know you did. You probably did to more than one person. I'm not saying you know what I'm saying, right? I'm just doing a presentation, so don't take it personal. All right, please don't take it personal. But you cannot say, I don't want to take your voucher. You have just set yourself up for a discrimination case, all right? It's not fair, Cassandra. I didn't make the law. But if we abide by it, we can get things done. And other lawful compensation. Keyword is lawful compensation. So if somebody say, yeah, I keep $50,000 under my mattress in cash, you better start wondering what's going on with that. What's going on with that? I would. All right. What constitutes discrimination? refusing to rent or sell housing. We'll get to that. Setting different terms, conditions, or privileges. We'll get to that. Engaging in steering. I'm gonna shuffle everybody over here that I want over here. I'm gonna shuffle this group over here. I'm gonna shuffle that group over there. You're steering. Oh, I don't want, hey, you know what? I have something over here for you. Oh, yeah, now you're steering. All right, that's discrimination. Refusing to provide reasonable accommodations or modifications for a disabled person. So somebody's in a wheelchair, why is the light switch way up here? Right, lower it. You have to do that. Oh, someone's in a wheelchair, they can't get over those stairs or those couple steps. Put the ramp in there. So this is a reasonable accommodation. So that is something that you actually are required to do. Making statements that indicate a preference. Well, we only want people that wear, I don't know, whatever kind of brand name people wear. I'm not. M&K, or we only want to rent to people who come from this location. We don't want people that have children. Yeah, okay. We don't want to deal with anyone that's, such and such and such. Making statements that indicate a preference is discrimination. All right. Saying things like, we have a no pet policy. What? But this person has a service animal. I always get a question about that, so somebody's probably gonna have a question about the service animal. Well, do I have to take them? Yeah. All right. We have a no pets policy, no matter if the person says it's a support or service animal. Now, here's the thing. We can't prove support animals. We can't prove that that's a service animal. Somebody says to me, can I use you? Sure. What's your name? Gretchen. Gretchen. Everybody, this is Gretchen. All right. Thank you, Gretchen. If I'm coming to rent to Gretchen, and you see you say, well, no, tell me you're not going to rent to, because I have a dog.
Oh, I can't rent to you because you have a dog.
But this is my service animal I need for emotional support.
Well, by law, then I can.
You don't know the law. All you know is you don't want this dog in your place.
It's so intensely.
Right? So guess what? I'm going to get a little upset, but I need this place. I qualify. I have my dog. I need my dog for emotional support. This is what I have him for. You're going to be like, aren't you? You starting to feel that way. We just playing. She's like, oh. But that's what happens. I've gotten those kind of calls. Those situations exist all the time right here in the village and in other places, right? So, but you can't prove. You say, well, prove to me that you have papers on that animal for us. I don't have to do that. And what you're doing is you're just making it a little bit more harder on yourself. Because if it affects me enough, guess what I'm going to go do? I'm going to go file. I'm going to make a complaint. All right? So, but there is a policy in HUD. If anybody ever go to HUD or you read HUD letters and whatever, HUD actually has a whole section on the pet policy and pets and service animals and emotional support animals. Somebody told me they had a cat, a dog, a bird, and something else. So how do I know what they were telling me the truth, that these animals were support animals? It's not for me to question there. But the problem was, how many heartbeats is that with the owner? That's 5 heartbeats. And you're in a 400 square foot place. How's that gonna work? That's what we talk about then when we go, okay, well, let's go into the options. Let's dig down a little deeper. So, it's four big dogs and one person in a 500 square foot place. I'm gonna be like, Jeff, what's the problem here? And then we have to talk about that and get the prospective tenant to see that we're creating a hazardous or unsafe situation, perhaps, right? But understand, be very careful when people are saying that they have service animals or emotional support animals and they want to rent from you, and you say, I have a no pet policy, because those animals are not considered pets. Yeah, they're dogs, they're cats, they're birds, they're the lady that tried to bring the peacock on the plane a few months ago. Yeah, no, that wasn't working. All right, but they're not considered pets. So be careful of that.
Hold on, don't keep going. What's the official stance on this? Like, a service animal is not a pet. That is guaranteed.
That's what HUD
But
says.
You can't go to the store and buy a service dog. But you can go to the store and buy a cat, a dog, a peacock, a rabbit, whatever. So, I just feel like the village isn't backing us up on this. A needy person with a service animal gets those through a proper organization. Somebody who needs support, whatever, is gonna have a physician's referral, a psychologist referral.
Maybe, maybe not, not all the time. That's what I was saying.
Well, see,
That's what I'm
why
saying.
asking you.
Well, that's,
I know
well,
that
well,
village
okay, well, thank you so
actually
much.
relies on it.
I understand. So I researched this myself too, because I had the same questions. Well, what happens? I'm one of those kind of people. Show me the paper. Show me the paper. I need to see the signatures. I need to see the documentation. I dug and I dug. I went to HUD's website. I read HUD's paperwork. I was making phone calls to people. And guess what? The writing, the way it's written, is still the open question that we have. Well, who's to say that that person is telling me the
Yeah,
truth?
we're not talking about
No,
that.
but
We're
listen to
talking
what I'm
about the Village
saying.
of Oak Park. You guys get to make your own.
No, we don't always, we don't override federal and all that kind of stuff. That's why I'm giving it to you. Yeah, if we could override some things, we would. That's why I said we talk about it, we dig deeper and see the reasonableness of it. For somebody to say, I have 4 animals and it's me, and I'm in a 500 square foot apartment, that's just not healthy, that's just not safe. And these are the tools and remedies that we may want to incorporate in that case. But if somebody is one person with a cat and say, this is my emotional support animal, so you have emotional support animals and you have service animals, 2 different things. Now, right, so a service animal probably did come through some agency, right? He's a trained dog or whatever he does. Most of the time they're trained dogs and things of that nature. But the emotional support, how can I gauge that? And that's where we're stuck. And that's where we're stuck.
You don't have to gauge it either,
But-
and it would be nice if there was some clarity on this.
I'm still working on the clarity.
It would help both sides.
I'm still working on
That's the
clarity.
purpose of government.
I'm still working on
To
clarity.
distance yourself.
Still-
You should deal with this proactively.
Well, I'm still so here's my proactiveness to you, sir. I'm still waiting on clarity. All right? Still waiting on, I have the same question you have. Still waiting on that answer. Because it is gray, and it does create just what it's doing right here. It creates this kind of dialogue, like, what about it though? But what about it? What about, I don't have that answer. I'm just giving you the black and white, and I'm still waiting on clarity. But trust me, I can't wait till it's a lot more clear than what it is. Because it's not just here in Oak Park. It's not, the problem is all over, and I see it in all different kinds of cities because I'm all over the place with this. So I see it, but it is something that I'm steady looking at and trying to figure out, hey, did anything new come down the pipe? Did they change that yet? So it's a real gray area, and it's a real, real tricky and fragile with this. Now, we don't get a lot of that, but we get, all it takes is one for it to be an issue. You don't have to have 20 cases, 1 case for it to be an issue. So, but in times past, since I've been here, the couple of times that we've had that issue, it's worked itself out with some conversation, right? Again, how reasonable is that? Or what else could we do instead of that? Or whatever it may be. And a lot of times, when we dig deeper, we'll see that it was really just a power struggle. The owner really didn't mind the animal being there. It's just that I want to see how far I can go before I say okay. Right? Just enough to teeter before I have to go to court and deal with something. Right? But, I'm sorry, I see you. But, just because it's a service animal or a support animal doesn't mean that the owner of that pet does not have to abide by the rules. They have to abide by the pet rules in the village. Clean up after your animal. Your animal's tearing up stuff, you need to do something about that. If you have that kind of animal that's attacking people, you need to do something about that. So they still have to abide by those rules. What we're talking about is whether or not the owner is going to allow the pet in the property. You can't say, I can't take you and your service animal or your support animal. Just like saying, I'm not going to take you because you got a housing choice voucher. You're opening up yourself for something. That's why we communicate and we talk about it. But they still have to abide by the pet policy in the village. So,
So I considered.
I'm sorry. Go ahead.
I'm sorry, I'm done. I'm just, say somebody has a cat that needs for emotional therapy, okay? I have people who are deathly allergic to cats,
Yeah.
right? It's just that simple. We have dogs in the building, we don't have cats. It's kind of an arbitrary rule, but there's a reason for it. So, somebody else, for their emotional needs, could put someone's very real physical needs.
And that's a good point. And that's why I say we dig deeper, we start conversing and communicating, and we get down to some other options. If that is, I don't want you to bring a cat on my property and somebody dies because they can't breathe. Guess what? Now I have an even bigger liability to deal with. So I understand it, but that's why I say we communicate, we dig deeper, and we get down to the bottom and say, well, did we really need that? Is this really the place for you? And this is what the bigger scope of that is. But you get a chance to say something, but I'm just saying, you just flat out said, no, I'm not taking it. Boom, that's it. What happened to the dialogue, or what was the reasoning behind that? All right, so it's still gray. So gray is a mixture of black and white. Hey, that's all I can say. All right, I hope that helped. Some. Okay.
Now, would it be considered steering if you told that person, well, I have a building that allows pets?
Not necessarily. That may be reasonable, right? Does the person qualify for it? Is that okay? So again, we go into the conversations that you're having with the person. I'm not being legal here. I'm not an attorney representing anybody, but just based on when people are, just like in real estate, everything is negotiable. Somebody's coming to you for an apartment, it's kind of negotiable, right? So hey, guess what? This one here, but I have this other one over here that is what? Is it comparable? If your intent is not to push them over there because they're this persuasion or this culture or this whatever, right? So the intent behind that was, okay, I have something a little bit more suitable, but guess what? Okay, but you have that dialogue, okay? Thank you, these are good questions, and thank you for bringing that up. I'm okay with this. I like it. Any other questions? I thought I saw another hand coming up. No? Okay. The last bullet on this page was what constitutes discrimination. When you don't have the staff that's trained in the latest tools used to communicate with people that have hearing and visual impairments. It's like, well, how is that my problem? Because you are sitting here to the public saying, I have accommodations, I have something you can come and partake of. If you're going to make that available, you have to make that available to everybody. So what do? Just develop other resources. I'm not here to tell you who to use. So, use, a TTYY service or whatever it's called, TT, whatever it is. I'm not saying that. What I'm saying is be proactive and make sure you have things and tools in place. You never know. So somebody come with you, let's say you don't have a hearing or a visual impairment thing in place. But if somebody comes to you, guess what? Hold on, let me see if I can get that for you. Just make it happen. We make stuff happen. Just make it happen. If that's something that, just make it happen. It'd probably take you an extra 5 minutes or 10 minutes, but save yourself some heartaches and some complaining and some other issues that'll go with that.
If perchance that does
Cool.
come up, are you a resource to use for recommendations?
If what comes up?
Like say you have to put a flashing light doorbell or something like that. If you're dealing with somebody with a visual impairment and you don't know what to do or who to turn to, can you guys recommend resources?
Well, you can call I'd say, hey, did you check such and such and such? So I don't have like a list of those kind of people, but I would do just like I would normally do. I'd be looking for that stuff. I'll hit Google, right? I'll just be looking for resources and things of that nature. Now, when it comes to the installation, you want to make sure that you're doing things according to the village code, then that's Jeff's department. Okay? All right, good question. Was there a question over here? No? Okay, let's keep going. Who is bound by the fair housing law? Everybody in this room. Everybody in this room that has anything to do with real estate, renting, owning, developing, insurance companies, newspapers, municipalities, real estate agents, everybody. Condo, housing associations, property management, all of us are bound by the fair housing law. You said, well, I wasn't born into it. Me either. But guess what? You own property. You're a landlord, you're doing these things or whatever it is, whatever you're part of in there, you are bound by the fair housing law. So you're just like, dang, it's another thing for me to deal with? Yeah, it is. But after a while, it becomes like breathing. Do you think about breathing? Yeah, no, we don't. We don't think about it. We just do it. So after a while, because if you're doing things right and fair and consistent across the board, you don't have anything that you're thinking about, right? It just becomes a part of life. You just live it, all right? Now, I'm going to break out those terms. We talked about discrimination in rental terms, conditions, and the privileges. The examples we have here. So you're going to discriminate in the rental term. You're charging somebody a higher amount and higher security deposits because why? Something in your mind said, hey, I don't like the way you look. So I'm going to charge you a little bit more. Oh, you came from that area. I think I'll charge you a little bit more because you probably have the propensity to do, yeah. No, that is discrimination in rental terms. A differential treatment, repairs, lease violation notices. She calls me all the time. I'm not going to fix another thing in her place, even though it's wear and tear. I'm not doing it. I'm just going to keep giving her stuff because, the person over here is complaining that she's turning her TV up at 6 o'clock p.m. So I'm just going to ignore this lady with this loud TV and just cater to these people. If you're doing differential treatment, that is a form of discrimination. All right, sexual harassment. I'm just going to keep, every time I see you, I'm your landlord. Gretchen, I'm your landlord. Every time I see you, I'm just going to be saying stuff to you. Yeah, I saw your kids the other day. Who was that person running in your house? Hey, you got people sleeping over your house? What? I'm just all the time in your face doing stuff. You need to move your car. You on the line. Hey, other people are saying that you, every time, I'm just, right? Yeah, I'm messing with you. But you haven't violated the lease, you pay your rent, right? You haven't violated the noise ordinances, nothing really, it's just me messing with you. You feel it? Okay, all right, so sexual harassment too. Ooh, that's a tough one. What do you mean? It is just not male and female anymore. It's all over the place. It's just not boss to subordinate. It could be neighbor to neighbor, right? So look, I get these calls, that's why I'm telling y'all, I get these calls. People are calling me saying, yeah, my neighbor, he or she or whomever, because it's both sides, was saying things to me, or they were following me through my apartment, right? Or I was moving and they were moving. Or they saw me coming out and they did whatever. Okay, but look, sexual harassments and harassments have to be proven. That is a whole nother subject matter, a whole nother class that we actually did have training on. So that's not my expertise. I'm just here to tell you that these things, you want to look out for them as a landlord or as an owner of property management company. Allowing tenant-on-tenant harassment, just like I was saying. It could be that. We have a case going on right now where there's a tenant that's in everybody's business, messing with everybody, taking pictures, doing this, doing that. You know, everybody comes in, bumping on ceilings, doing all kinds of stuff, right? If you're allowing that to happen, you want to crack down on that. That's why we're doing a whole crime-free deal. You want to crack down on things that are going on in your buildings and your properties that could escalate to other things and end up being discriminatory or end up being other things that require mediation in lieu of the court system. We don't have time and money and resources to be filing cases and going to court all the time, when we can have some behavior adjustments based on communication and knowledge of the laws and the ordinances that are in place. Does that make sense? Yay, thank you. All right, I'm having fun with this, as you can see. Denying a housing choice person, you don't see this is my note. Denying housing choice voucher because it's a voucher. We keep coming back to that, and I noticed when LaTonda did the presentation, there were no questions. See any questions? It was silent. Because I know the housing choice voucher piece is very sensitive with a lot of owners and management companies. I see it all the time. Because people don't know, should I or should I not? What's my limitation? Treat everybody fairly. If you know that the housing choice voucher is a source of income, you treat people fairly. You take them through the same screening process. I'm not saying take people's money, but I'm saying you treat everybody fairly, then you won't have any issues of defending yourself if somebody brings a case against you. You didn't rent to me because I had a housing choice voucher. That's not true, Gretchen. I didn't rent to you, not because you had the voucher, because I had other people that qualified that were better, that met the criteria, that could pay fair market, right? But they had a 650 score, just like you had a 650 score, right? They had whatever, just like you had. But guess what? My choice got down to I wanted the fair market rent. But guess what? I took you through the screening process, right? You did your application. I ran your background check. I ran your credit. I did those things I needed to do. I didn't accept you not because you had a housing choice voucher, because that's against the law. And I'm not going to lose my license or my property for that. All right, so y'all, that was an example. I'm just giving it to you. Pay attention to that. But that's not why you do it. And I still hear people doing it today. No, we don't want that. We're not going to take the voucher. No, I don't want the voucher. You have a voucher. And all I can say is you might want to watch what you're saying, because you are setting yourself up according to fair housing laws. All right, let's talk about tenant screening. I just said a few things about screening. Any questions before I move forward? No? Okay, thank you. All right, tenant screening. Earlier, Officer Jacobson, in his presentation about crime-free, was saying, make sure you screen your tenants. Make sure you do your background checks. Because, hey, how many times have people probably ran and saying, yeah, my cousin, my friend, my relative, or whomever is here, and they're looking for a place to stay, and you go, oh, because Gretchen is such a great tenant. Thank you so much. I owe you something. No, because Gretchen is such a great tenant, guess what? I guess her cousin, her friend, or whomever is going to be a great tenant too. They look at Gretchen because she is the epitome of what good people should be. But that don't mean that they are, right? So I'm just going to take a chance and rent to her cousin without a screen. with no background, no credit, just because Gretchen was like, my cousin needs a place, and I like Gretchen. Okay, person gets in there, it's just out of control. Just out of control, just messing stuff up. That's on me as a landlord for not doing my screening. So when you do your screening, do the full legal name. What's your name? My name is Joe. Is that short for Joseph? What is that short for, right? Get a full name. Accurate social security number, you're gonna verify the income, remember the source. Employment history, credit history, do the full shebang if you can. Now, one time I said I would go so far as to go and check and make sure that the company that they said existed. But that's just me and my OCD with the way I would do it. Because I know of someone who before had pretended that they had a place of employment, and a phone call was made to a person who was professional enough. Hi, yeah, thank you for calling. Yes, I do know him. Is he such and such? Oh, yeah, he's what's the whole thing? Person was that person's cousin playing games. The guy got the apartment. He did not pay rent. Awful. But that's just me and my preference. So I learned a lesson from that. And I tell that story every time I do this presentation, that just be on your game and make sure you are doing proper screenings. Now, they have screenings on the website. You can go to these organizations that'll do the screenings for you. So if you say, I don't have time, I don't know what I'm supposed to be doing, is it going to cost me this? Use the screening devices that they have on the services, because guess what? The tenant then is in control of their own information. If they don't pay the money with the card or whatever online, guess what? The background check and the screening never happens. But that is off of you. You don't have information, so you don't have to have their social and stuff. Let them do that. You're going to have it on the application. But you let them do their own, pay for that service, and get that screening done by a third or fourth party, whoever you want to go use. This way, your hands are not on it. They can't say, oh, you looked at my background and you said this. Well, I didn't start it. You initiated that. All right? Put that onus on them. Be consistent. That's what you need to know. Be consistent across the board. Requirements for persons with disabilities. Again, I talked on this a little bit about somebody being in a wheelchair with a light switch up here. Modify it. Put that light switch down. Folks that in tubs who need to get out, if you have to put in a safety bar if they ask you for it because they need it, then guess what? Landlords, you're supposed to do that. A reasonable accommodation is what that's called. Modifications for that. The landlord is responsible for the cost of the changes if federal money is received. Otherwise, the changes are at the expense of the tenant. So if some of y'all would think, well, I got to pay for that. Well, not necessarily. Depends on how you're getting your funds. Now, if you're receiving the federal money, we're talking about things like, I'm just going to say the voucher and things like this, then yeah, it's expected that you would make some modifications. But otherwise, the tenant needs to pay for some things. All right? And reasonable modifications, again, for persons with disabilities. We were talking about that. What are some things that are easy? Letting them park close to the door, right? Well, your parking space is way over there, sir, up the ramp, and that's what goes to this unit. What? Well, let them park closer to the door. Make that modification, all right? I got a wheelchair, and the standard of the doors used to be, what, 28, 32 inches, and now I got this wheelchair, I can't get through. What do I do? You need to widen the door. All right. I can't physically come and pay you the rent. Can I mail it? Or can you take it out of my account? We got a lot of technology, a lot of ways to get things done today that you don't have to box yourself in and find yourself in situations with people. Because the people like to file suits for some reason. I don't know. All right. Some about that. Examples of what the law requires if needed by a person with a disability is what we just saw, the parking rules and all that kind of stuff, ways to get the mail, way to pay. Okay, let's talk about the pet policy. Exceptions for a service dog or emotional support animal, we talk about that, right? You can't refuse to rent or discriminate in the terms, conditions, or privileges of a person with a disability or support animal. For example, if your pet policy fee is $250, it needs to be $250. Just because they say they have an emotional support animal or service dog, you can't jack it up to $500. All right? Be consistent. You cannot charge a pet deposit if it's a service animal, though. You can't charge the pet policy, but I was just giving you a discriminatory practice if you were trying to charge somebody more than the other. But you can't charge a pet deposit. But you can charge for the actual damages, which was what I was saying. If somebody has a support animal or those kind of, the service dog or whatever, they have to maintain their pet They gotta clean up behind them, they gotta feed them, do whatever it is that you do when you have an animal. They have to do the same stuff. That's not special. There's no exceptions for that. Be consistent. How to protect yourself. Be consistent. That's what we're talking about. Learn about the fair housing laws. If you're a management company, you need to train your staff and make sure they understand. They're always giving fair housing training in the state of Illinois at some place. If you are not sure of when or where, you want some information on it, you have the Oak Park's real estate board, right? They're heavily involved in fair housing because they have to be. They're realtors, all right? Challenge the stereotypes. Go to some diversity trainings. LaTonda gave us some myths about what people think folks with housing choice vouchers have and are about, which are not true. Not true. All right, so challenge those and apply the policies and the practices consistently. Be consistent, cover your butt, do it the right way all the time, and you shouldn't have any problems with defending yourself if you needed to. All right, if you are a housing provider, and something happens, this is what I mean by you be able to stand because you have the documentation showing that you have been consistent across the board. Tell the truth, first and foremost, because if you get found out or you're under oath, you know that turns into more things. Keep your good records. Document the actions. Every time you had to go to that building or every time you had to call or every time that person was late, every time, whatever it is, document it. Keep a note. Keep a record because, again, if you got called into a case, you have to prove your side. So have your stuff together. Have your stated policies and practices and follow them consistently. What's in your black and white will keep you right. Your black and white will keep you right. And I mean the writing that you have in your documentation. You all can steal that, it's a rhyme, you can have it. All right? Document the reasons for deviations from policy. So if you had some special exceptions, make a note of that. Yeah, I allowed that because this was a service animal. It was okay. Document any deviations and be able to support the deviations that you have. All right? Other resources, if you want tips and stuff, you can go to our website or you go to HUD.gov. They have a lot of stuff under there. The Illinois Department of Housing has information. The Illinois Human Rights Act has information. So, if you take some time and become educated on some things and learn some other, dig down deep in some of these topics that we spoke about today, that's awesome. All that's going to do is help you and enhance what you're doing. Because after all, you're really in business. Being a landlord, you're in business. You have things that you have to maintain, things you want to make sure happen. And the thing is, the big thing about the fair housing is you want to abide by the law, stay out of trouble, stay out of the courts. Any questions? Comments? I'm done. Thank you all.
I just wanted to clarify, if I could, Jeff. I talked about barbecues and fire pit use. I told you that 10 feet is the distance from a combustible structure. That's the way it is for barbecue grills. But if you have a fire pit, it's supposed to be 20 feet away from a combustible structure. So I made a copy of the ordinance. I'm going to put it up there. We do get a lot of questions from landlords, saying, their tenant is barbecuing and, can you provide me information? So I'll put that over there so you can pick it up if you need it.
Just want to follow up a comment here. How many of you do not believe you own a business? Okay, because you do. Each and every one of you own a business. It's your rental property. And if I'm a business owner, I'm going to have in my resources somebody I can turn to, and that's going to be an attorney. And we strongly suggest you have an attorney that you can go and ask questions to. Neither Cassandra or I are lawyers. You need to have an attorney. And the type of attorney you need is somebody who's familiar with rental law. You don't need a divorce attorney. Well, you may. I don't know your situation. But you don't need a divorce attorney for your business. You don't need a patent lawyer. You need somebody who is familiar with rental property law. And because the property is located in Cook County, you need somebody who practices in Cook County. All right? So that's just a little suggestion there. I'm going to be talking to you about rental licensing inspection ordinances. This has changed. This will impact you moving forward. Caught your attention there, good. How many of you have what we're going to refer to as 3 or 4 units of rental dwelling license? If you just raise your hands, I need to know where my audience is today. Okay. The rest of you, are you 4 or more unit owners? Is that correct? All right. The 4 or more unit owners that I'm going to call multifamily licenses, that has changed dramatically. The people who own 3 or fewer units that have the rental dwelling license, that hasn't changed as much, but there has been a change, a positive change to you. First of all, the fee. The fee for the rental dwelling license is the same as it always was. It's $10 per unit. The fee for the multifamily unit is $20 per unit. Okay, Jeff, where's the change? Well, here's the change. Renewals. All the renewals now are due December 31st. They used to be due in October. They've been changed. All the renewals are now due December 31st, whether you're a rental dwelling license or you're a multifamily license. Your rental dwelling license, this is where the good change has occurred for you. Your licenses are now 2-year license. They're no longer a 1-year license, it's 2 years. So every 2 years, you will get a renewal. And every 2 years, you pay as opposed to every year. The multifamily owners, a little bit more complicated. We've changed it to a performance-based license, okay? A performance-based license. Let me explain a little bit here, all right? The performance-based is only going to apply to 4 more units. What we rely upon are the building inspections that we conduct. Now, if you're familiar with Oak Park, what we've done in Oak Park is if you have an even address, we inspect your property on an even year. If you're an odd address, we would inspect your property on those odd years, but only if you were a 4 or more unit. Well, again, that's now changed because we're basing it upon the performance. How well of a landlord are you? How well are you upkeeping that property? If you're upkeeping that property good, we're going to give you a gold license, or possibly a silver, bronze, or a conditional. That's how we classify them. Those licenses are good for 4 years, 2 years, 1 year, or 6 months. So if we come out to your property and we inspect it and there are hardly any violations, you will probably get a gold license. And what that gold license means to you, 4 years. 4 years without having us come back to you, 4 years for you not having to pay. Let's take the other side. If you're one of those landlords that we really don't want to be talking to, or we do want to talk to, but we don't want, we want better communication. It could be your property needs extreme help. In that case, it's going to be a conditional license, and your license will be renewed every 6 months. Performance-based. We want you to succeed. Okay. We've got a chart that I'm going to go to and explain a little bit more, but this basically breaks it down, and I'm going to break it down a little bit better as we move forward. But remember, we inspect even property on even years, odd properties on odd years. On top of that, we only inspect a third of your units at a time for multifamily. Boy, your single family, your small rental people out here, you're liking your small rental property, right? All right. For your multifamily, again, it used to be every other year. Now it's going to be based on your performance. But when we do get out there, we still are only going to inspect a third of your property. Okay. So let's talk a little bit about the ordinance. All right. This part of the ordinance has not changed. All right. This basically is saying that we have a right to inspect your property. This part of the ordinance under the housing, chapter 12, 12-2-1G, it basically says that the property inspections licenses now are based on performance, based on property violations and nuisance violations. Remember when Sergeant Jacobs was talking about nuisances? your license can be impacted upon the type of nuisances that you have on your property. Another change, okay, what if somebody calls in between my normal inspections? Is that going to count against me? The answer is no, as long as that violation was corrected before we come out there to do the normal inspection. What am I talking about? You all have tenants who call me. And the first thing I ask them is, have they called you? Because that's what they should do. They should be calling you first to address the problem. If a landlord is unresponsive, that's when I want to hear about it, and we will reach out to you to find out what's going on. There's always a he said, she said possibility. There's two sides to a story. But what we want to do is we want to correct that violation that the tenant has brought to us. If that violation is corrected before we do your annual inspection, it's not going to count towards your inspection, towards your license. This is the big change. Again, it's talking about the frequency of your inspections. The frequency of your inspections is going to be dependent upon how good of a license you have. If you'll notice, we've taken our licenses and we've expired them either 4 years, 2 years, 1 year, or 6 months. We've categorized them as gold, silver, bronze, and conditional based on the performance that you have. These performances are based upon the number of violations per unit of those units that we inspect. I know you never wanted to do math again, but here we go. All right. Let's say that you have a 30-unit building. Well, I say that we do a third of those units, correct? So a third of those units is we're going to inspect 10 of those units. If we happen to come up with 33 violations at this location, we're going to take those 33 violations and divide it by those 10 units, and we're going to come up with 3.3 violations per unit. If you look up at the chart, if you've got more than 3.3 violations per unit, you're going to get a conditional license, 6 months. Take a look at another example. Let's take that same 30-unit building and you're maintaining it properly. Again, there's still going to be 10 units that we're going to inspect, but now you only have 7 violations instead of those 33. 7 violations, I'm going to divide by the number of 10 units that we've inspected. I'm going to come up with 0.7 violations per unit. If you look at the chart up there, if it's up to 0.75, you're going to get a gold license. What a difference one violation will make. If we inspect this same property and you come up with 8 violations, 8 divided by 10 is going to be 0.8 violations per unit, you are exceeding the gold license. You will end up with a silver license. We want you to succeed in this program, okay? So if there are any questions about what we will be inspecting, please get in touch with us. We will gladly give you a handout. Matter of fact, there's online, you'll be able to obtain our checklist for what we look for. The most important things that we look for are smoke and carbon monoxide detectors, life safety issues. Those are the things that get the property owners dinged the most. Okay? Here's another thing that's changed, reinspection fees. Okay? Reinspection fees, it says that due immediately following the second inspection, every subsequent inspection conducted thereafter. All right? What else is a reinspection fee? Well, a reinspection fee happens when somebody's not present, okay? You get your initial inspection, you get your follow-up inspection. Those are the 2 inspections you get. When does this reinspection fee kick in? If we have to come out to you a 3rd time, or a 4th, or a 5th. And yes, it does happen. Okay? Ideally, we'd only like to be out there once. And in that situation, you'd have 0 violations and you get a gold license. But we know that we're probably going to do a follow-up. We're going to give you that second inspection, no problem. But if you go beyond that second one, you're going to have a reinspection fee. If we set up an inspection and for whatever reason we're not informed that you can't be there or there are circumstances that are going to cause issues where we show up and it's a no-show, that's also where there's going to be a potential for a reinspection fee. Get in contact with me. Let's talk about what happened. Okay. What are the reinspection fees? Okay. 4 or more units can be $20 per dwelling unit and $50 per common area. Please do not go towards the reinspection fees. Okay, you don't want to go there. We don't want you to go there. All right? Okay. I'm going to shift a little bit here and talk to you about something that I think is very important. When was the last time you set eyes on your property? When did you last set foot on your property? When did you inspect it last? Do you inspect your property monthly? Inspect your property quarterly? Yearly? Or maybe when the tenant moves out? Anybody inspect, just out of curiosity, anybody do it monthly? Okay. Very good. We had a quick show of a hand back there. I had somebody in a class that I was teaching once that they said that they do it monthly. When do they do it monthly? On the first of the month. When they're doing what? Collecting the rent. Okay? Kind of smart. Why do we want you to do inspections? Because we don't want this. We don't want you coming in and finding that you've got unsanitary conditions. We don't want you coming in and finding out you've got a sewage backup that's been there for a couple of months, even a couple of weeks. We want to make sure you don't show up and find this. If you're doing inspections, you will be able to nip this in the bud. Matter of fact, I strongly suggest you get in contact with that attorney I told you should know. And in your lease, I strongly suggest you have some wording in there that would prohibit this, excessive garbage collection. This is an unsanitary condition that's blocked exit. This is unacceptable. This is questionable. Believe it or not. Okay? There are some people who collect items, sometimes collect brand new. They will go and they'll just order stuff online and they'll stack it up. Okay? Those people have brand new material, brand new product there. It's clean. Okay? Do we have anything that we can enforce on things that are just stacked up? Well, if you're blocking an aisle, we can. But if all I have is all my new, neat stuff stacked up, and I've got aisles that I can go through, there is absolutely nothing that I can do to enforce that. However, if you have something in your lease that would write to that effect, whether it be excessive amount of material, piling up of material, okay? And this is where I'm saying contact your attorney to see if you can get something in there. Because here's the big rub on all this. Who's responsible? Well, it depends, okay? Unsanitary conditions. Well, the owner of the premise shall maintain the structure in compliance with the code. And it says here, a person shall not permit another person to occupy a premise which are not in a safe and sanitary condition. All right. If you own a multifamily building and you get complaints from your other tenants that, there's a strange smell coming from this unit, guess what? You've now just been notified. You can be held responsible for those unsanitary conditions. Just like the person who is the occupant can be held responsible. And I will tell you, we have gone after both. And we did it for legal reasons. If you're putting your eyes, your feet, inspecting your property, hopefully you're not going to get to this situation. The other thing, what about occupancy limitations? Your leases say who can be on that property, correct? Well, if the tenants are exceeding that, who's responsible? Well, a person shall not permit another person to occupy the premise that do not comply. Well, one of the first things I'm going to start doing is calling you and asking, well, do you know how many people are living there? And if we find out that we actually have more people than should, that's going to shift back to you to take some responsibility, as well as the people who are actually occupying the premise. What about plumbing fixtures, mechanical, electrical, things of those nature? All right. Well, a person shall not permit another person to occupy a premise who do not comply with requirements of this chapter, meaning the code, the property maintenance code. Why do you want to go on your property and do the inspections? Well, the obvious ones are the pictures, the dramatic pictures that I've showed you. But you have a leaky faucet at your house. Do you fix it? Yeah. You got a squeaky door. You got small minor issues at your house. What do? You fix it. What do your tenants do? It's not mine. Right? It's your property. It's not theirs. You have to take care of it. Remember the old Midas commercial? You can pay me now, you can pay me later. Same thing applies here. If you get eyes on your property, if you're getting inside those rental units and taking care of those minor things now, they will not become major things later on. Unfortunately, like I said, common sense is not common sense to everyone. You would think that somebody would notify you, but we all know that they don't, right? Yeah. This is the checklist. It can be found in the form section. It basically tells you what we look for when we go out to do our inspections. I've got 3 property maintenance inspectors who go out. The town is divided into 3 different areas. They look at things like doors and windows. They take a look at the walls, ceilings, and floors. And what we basically have instructed them is, would you live there? Because that's how I want to look at the property that we have here in Oak Park. I may not like the layout. I may not like the location, but would I live in this situation? Would I live in this unit? And to me, the answer has to be yes. Not because of the location, not because of the style, but is it something that I could live in? And that should be the same question you should ask yourself for maintaining those units. Yes?
A disclaimer first.
Sure.
You inspect me, but it's not every 6 months. But if you had to do the biannual, would there be the fee that's attached to that
Yes,
every 6 months?
that's correct. Just like if we inspect you every 4 years, you only pay every 4 years. If we inspect you every 2 years, you pay every 2 years. Every 1 year, 1 year. It's performance-based. You can see the meaning behind our madness. We want you to take care, we want landlords to take care of the property. Yes.
When it comes to inspecting the unit, what are our rights? How do we get access?
Your leases should have written in them the authority for you to inspect. And if I'm not mistaken, most of you have, what, a 48-hour notice clause? 24, good for you, okay? A lot of people I come across talk about 48 hours. They have to give them 48 hours before they can get into the property to conduct inspection. You have a right. It's your property, okay? I have a brand-new Maserati. I have a brand-new Cadillac outside. Am I going to walk up to somebody that I don't know and give the keys to that person without knowing anything about them? No. There's your background checks, people. Am I going to not check up on that person every so often once I do give them the keys to my car, my brand-new car? Yeah, you're going to check up on them. There's your safety inspection. Those are your routine inspections you need to do. It's your property. You have to protect it. Because if you don't, it's going to fall into the next topic we're going to talk about. Good question. Anybody else? All right.
Sir, how many
Yes.
hours do we have to speak to the tenant in order to make, to check the apartments? 24 hours in advance? Or?
Your lease is going to determine how much notification you have to give them before you can do an inspection on your property. Okay? And those 24 hours, those 48-hour notices, those can just be routine. But if you tell them, look, I'm going to do inspections every 3 months, every 4 months, they know you're coming then. And oh, by the way, as you're leaving, I'm going to be back in 4 months, I'm going to be back in 3. If there's anything that comes up between now and then, call me, right? I want to be there for you. I want to make sure that I'm providing you the best service possible.
So if the property manager doesn't do it, check out every first of the month? Someone can do it.
Again, that's something you have to make. That's a decision, a business decision you have to make. Do you inspect every month? Do you inspect every 4 months, every 3 months, every 6 months? Hopefully not every year. Okay? All right. We had a wide variety of people in here, wide range. And now I'm going to ask you some questions. Who in here has dealt with an eviction? Okay, new people, look around you. Hold your hands up again, please. Okay. He says, tongue-in-cheek, how'd that go for you?
Expensive.
Expensive, okay. Can you share? Was it, where did your expenses come up?
The legal fee was $1,500.
Legal fees, $1,500.
Lost rent, damage,
Lost rent, and,
my time, damage
okay,
to property.
damage and time. You got 4 different areas there where you can lose money. Yes, sir.
Also, your documentation, that can make the process start all over again. If there's one, if wording is wrong, or something isn't right, or you missed a step, the onus is on you, unfortunately.
Yeah. Again, you own a business. I don't own rental property, but the first thing I would do, I would get an attorney. Because, now, attorneys do make mistakes too, but there's a less of a likelihood if you go through that eviction process that you're going to have any problems. But you're absolutely right. We've heard horror stories. Somebody didn't do one thing right, and guess what? You go not back here, but all the way back to the end of the line. And it's a long, lengthy process. If I can ask you, how long did the eviction process take for you?
About 4 or 5 months by the time.
4 or 5. Anybody longer than 4 or 5? Sir?
6, 7.
6, 7. More than 15? Okay.
Same thing, especially during the winter months.
Yeah.
Where they don't choose to evict, so it's a long process.
Yep. Cook County, in April, was just starting to do was processing their December and January evictions. Okay, you're absolutely right. There's a humanitarian aspect of it, and we all get it, being humans. Do you want to put somebody out in the cold? It doesn't do you well when you're sitting there having to not get rent and knowing your property's possibly being destroyed. Okay. Anybody else have any other stories they want to share? Because trust me, you want to provide your other landlords here with solid experiences. Yes, sir.
Usually just pay him some money. I tell him that the legal cost is gonna cost me $1,000. That's your money. You want it. When you move out, you take it. I have some paperwork.
Some people do try to take that route where they pay them to leave. Cash for keys, I believe is what they call it. Okay? Again, consult your attorney.
And there's also another site, I don't know if you're done, it's called Bigger Pockets. There's a whole bunch of landlords on there, and there's about 287 podcasts that comes out every Thursday. It's about all the states that have made it. It's free. It's a website called Bigger Pockets, and
Bigger Pocket, is that what I'm hearing?
yeah, and it's free.
Okay.
There's a paid version and a free version. And there's like 800,000 listeners every Thursday, and they're all using that.
See, you people coming here today didn't think you were going to learn a thing. Bigger Pockets. Okay. Thank you. Thank you. Anyone else with a eviction? Yes.
I have a
Question.
question. Getting back to the inspection.
Yes.
Getting into the apartment. If you have on the lease that it's 24 hours and you give them that notice, do they have to be there?
What's your lease say? Because some leases are specific that, they have to be there. Some you should have a right to go in and onto the property, even if they're not there, just to do your routine inspection.
I think it says 24 hours, as long as we give you 24 hours, we can get it. But if the tenant gets back and say, I do not give you permission to go in without me being there, does that squelch
Okay.
what's on the lease?
Contact your attorney. That's
Okay.
okay. That's an attorney question that you need to resolve with yourself and what you have in there, okay? And if somebody doesn't allow you access the way that you feel, just like we're going to talk about some other things, what you have options, do you not? You go into a property and somebody's painted the walls red or green, whatever, your beautiful white walls. Does your lease say that they can do that? No. So what do? You serve them a 10-day notice to correct. You come back after those 10 days, and if they do not correct, you have the right to start the eviction process. Same thing with this, is that this situation could potentially be something that could be a breach of your lease, depending on how your lease is written. That's why I say contact your attorney. Yes, sir.
This lease situation, I know everybody has their own leases and all that, but Chicago Association of Realtors come out with Chicago lease every year. You just Google that. But then if you want anything outside the city of Chicago, there's a Main Street Association of Realtors. If you just Google Main Street Association of Realtors lease, they have a lease that's created by attorney that's technically legally used for Main Street Association of Realtors, but it happened to be on Google, so I guess you could use a copy of it and see if it works out.
I will caution you one thing, though. That crime-free lease addendum has to stay an addendum. Well, why, Jeff? Well, here's the reason. We've had some people that say, well, I've got that wording in my lease. Well, once that wording is in the lease, they can just say, well, I've corrected that situation. I'm a criminal, right? You've come to me under the crime-free lease addendum that you've written into your lease. It's no longer an addendum, it's part of the lease. Basically, you're going to say to me, here's your 10-day notice, stop your criminal activity. You come back 10 days later, I said, I've stopped, I've corrected that situation. Whereas the crime-free lease addendum takes it outside of that and allows you to push forward on an eviction process. So it's important to have that crime-free lease addendum not included in your lease itself. So that's my only cautionary. If you're getting some documents that are pre-written up or by somebody, just make sure that that crime-free lease addendum is a separate item and signed by who? All people above what? The age of, 18. You want to have all adults sign that crime-free lease addendum. I know that.
One for each, I'm sorry, one for each, or you can just sign the one?
You can probably have them all sign the same, but again, that crime-free lease addendum is part of your lease. And if let's say you weren't using it, and all of a sudden, oh, I've got to. Well, if somebody already has a lease, you can't force them to sign that crime-free lease addendum because they have a lease. The only thing you can do is wait to the renewal process, and then you can have them sign that.
That's not my case, I've been using it since 2013.
I didn't suspect that. I'm just throwing it out for additional information here, okay? But if, you might want to have a separate document, okay? Again, I'm not a lawyer. It's a piece of paper, you know? But one of the things, definitely get them to sign and even make that perhaps even make it a requirement in your lease when when any juveniles do turn of age, that they are required to sign, you know? It's Junior's birthday, great, here I am, here's your crime-free lease addendum, we need it signed. Yes?
Do you have to have them sign it every single lease renewal, or the once is good for all? I do it every time, so.
It's not a bad practice, because do you have them sign the lease every time?
Right.
Yeah. And that crime-free lease addendum is part of that lease. So it should be signed and dated, just like your lease is. So my recommendation to you, again, I'm not an attorney, would be to have it signed every time. Good questions. Yes, sir.
My question is with this access issue, I hate to bring it back up, but just in my experience, it just depends on the municipality you're in, how involved the police want to get. Because
Yeah.
if I'm saying that I have a lease and I have paperwork and I want access, it depends on the person. That person could say they don't want to have you access and sometimes even be there and say, I'm not going to let you in. Call the police, and I've had instances where the police will stand there, they will see the paperwork, and I even show that I served the notice, and I put it on the door, and I said I needed to get in, and I did everything, and he says, well, we're not going to get involved. You know, so it still has to go to the courts. We're not going to step in and make you go into that person's room.
Okay. Unfortunately, what you're describing is probably pretty accurate, though, okay? You have more power than the police, okay? One, because you can evict somebody. The police cannot evict somebody. The other thing is you have a right to access property through your lease. The police can't. Something called the Constitution that prohibits that, them just entering onto the property. And that's where the problem comes in. When you present them paperwork, when you present the police, hey, I'm here to do an inspection, and they're refusing the entry, you're basically documenting that on a police report, because the police will not force entry for you. The only time they will force entry is when? Life safety issue. If there is a life safety issue, given the circumstances, and every circumstance is going to be different, they can force entry at that time.
And I was even asking him too, but they called him. I was just going to walk in, but he advised not to because
Yeah,
now
you're,
I'm here and I'm not going to get into it, but I can't allow you to go in.
yeah. What will happen is your tenant will be proactive and call the police before you. Say, hey, my landlord's here and I'm telling him he can't make entry. I don't want him to. All that you have to do that I can say is present all the documentation, make sure that the police are recording that, look, I'm here on a routine inspection, here's the lease, here's where it says I can have a routine inspection, here's where it says I've given them notice, here's the document that I sent to them, certified, or here's the picture where I posted it on their door 2 days ago, and go from there. And yes, it's probably going to turn into a court issue at that time, which is probably leading to the fact that there's more going on than just you doing that routine inspection. Yes?
I would recommend be careful on thinking that police reports will take into account in your court cases. Lots of times the judge will throw it out as hearsay unless you, and from what I believe, you have to actually have the officer there to sworn in to testify on what they've written down. So don't just bring the report saying, here's the report, judge says it's hearsay. Be careful with that.
It's very likely that could happen. The other thing is, when we move forward to this section we're going to be talking about, you now have to be like the police in preparing cases. A gentleman down here said if there's one thing you don't do right, it can get tossed. You can move back to the end. Well, that's your case preparation. That's what you need to do to prepare the case so that you can succeed legally in doing evictions. Okay? Now, in the back there are two papers that I did provide. I hope you do take them. Tips for landlords when tenants fail to pay rent, and then also the Cook County Plaintiff's Guide to Eviction Procedure. Okay? But let's get into this a little bit. Non-payment for rent is probably the number one issue for evictions. Let me ask a question. And it could be a friend of you that you know, don't have to say it's yourself, but if somebody doesn't pay you the rent, hey, look, Jeff, I don't have the rent this time, can you take half of it? What do you say? Pardon?
No.
A little louder, please.
No.
Thank you. Why?
They're changing their rent amount, first of all. Second of all, once you accept any money, then you've accepted rent for that tenant.
Right. A little louder back there?
It takes you all the way back to the beginning of the 5-day service.
Right. Right. You,
To direct deposit, they pay rent, like if they have an account they can put it in, do you put rules in they only accept a check for a full amount?
I have personally stopped people from paying online because they weren't paying their full amount.
Yeah.
Blocked their account.
yeah. Somebody once told me, and maybe you can fill this in so I don't have to commit myself. There are two people you don't want to rent to. One would be your best friend, and the other would be family members. Somebody said here, not I. Okay? So, yeah, those are the two that come up that run into problem. Okay, so let's remove them from the picture. Now we've got our tenant that we're dealing with. What did I say you have to treat this rental property as? A business. Okay? I go into a big box store, hey, this looks good, but I don't have all the money. Would you accept half of it, half of the payment for this today? No, the big box store is not going to do that. You're a business. Do not accept half payment. This is where the human comes out, okay? And people do it. And sometimes if that human factor, they plead on you and you say, okay, just this once, and it works for you, great. But just as many times as that happens, there are the other stories where people say, well, okay, maybe just this once, and then all of a sudden the rabbit hole. Where they're not paying rent this month and next month, because it's always something, isn't it? Well, my car, I have an issue with my car, I need transportation with my car. I've got this I've got an expense for, I've got that. Well, you have an expense yourself, don't you? Mortgage payments. Those need to be satisfied too. Yes, sir.
If somebody mails you a check, and it's not for the full amount, and you open the envelope or whatever, is that considered acceptance, or is it acceptance when you deposit?
Is somebody up there?
Accepted when you deposit it.
That's right.
Excellent.
Your 5-day notice you can state on there how you want to receive your, or 10-day notice, how you want to receive payment. And you can specify on there, you can ask it to be, whatever you feel comfortable with.
Yeah. And we talked about when you do your tenant screening and you're giving them the ground rules, lay it out right up front. This is a business, I just want to let you know your rents are due at this time. If you don't pay by this time, okay, you have 10-day grace period, 5-day, whatever your grace period is. If you don't pay by that grace period, I will be serving you with a 5-day notice. A what? Yes, a 5-day notice, or 10-day notice, sorry. a 10-day notice to pay. Okay? So you can provide them that and let them know that this is what you're going to do up front. Let them know the ground rules so that there are no surprises. Now when they come to you and they say, hey, Jeff, I don't have this month's rent, I said, well, I'm sorry, remember that conversation we had when I rented the property to you? I understand your situation, I know it's bad for you, but I've got to serve you with a notice if you don't pay by this date. It breaks my heart, but my attorney, blame it on him, yes.
Yeah, and any payment arrangements that you make with the tenant, have them in writing and have them sign it. Once they reach that, you'll have to start the process.
Yeah. Now, this section that I'm talking about deals with the other aspect of evictions, okay? And I want to make it very clear that there are two sides of this eviction process, and you have to be aware of that other side. You have to be aware of that other side so that you can still live in the house that you live in. As I tell people here, I live in a very small house, but it has a roof over my head and it keeps me dry. I want to keep it that way. I don't like to get involved in lawsuits. These type of lawsuits are federal lawsuits that they've all talked to you about. Okay? You have to be aware that evictions can start with non-payment. We've talked about that. Lease violations, somebody paints something and you want them to change it, they don't. And holdover tenants. Tenants have rights. And that's what I want to talk to you about. There are key laws covering evictions. One's the Forcible Entry and Detention Act. You need to look it up, read it, read the Cliff Note version, but become familiar on it. This is your business. The other one is Safe Home Acts, which you may not have heard about. There's a couple resources we want to make you aware of. Is the Illinois Legal Aid Online. It's a good resource for finding out information about legal aid, legal information. The other one is the Illinois Association of Realtors. They have a practical guide for landlords in Illinois. These are not the only two that are out there. Okay, there's Google, find information, do the searches, okay? There's a wealth of information about what you have responsibilities for and what laws that you have to apply for. The other thing that I also suggest is, I believe it was you, sir, that talked about the handbook for Oak Park.
Yes.
That's being rewritten, okay? One of the things that we suggest is when that comes back out, and it'll be in electronic form, provide that to your tenants. Hey, guess what? Oak Park has this beautiful thing. Here's the book that Oak Park puts out. Provide your tenants with information. Right? The Illinois law protecting victims of violence. This is a huge, huge issue, especially with crime-free. Okay? We do not want to make victims out of victims. And that's the bottom line. That's where all of this came from. We don't want people who are already victims, battered or sexual, to become victims by being forced to be evicted. It's against the law, people. You can't do it. And there are certain requirements here. Okay. The Illinois Human Rights Act prohibits discrimination of order protection status. Okay. You can't discriminate. Somebody comes to you and says, hey, I've got an order of protection against my significant other. You can't take any action based on that. They're protected. Okay? You can get yourself in trouble for that. They have rights. There's a reason why we allow them to go get that order of protection. It's for their safety. They need to be safe. They need to make sure that they feel safe. Don't make them feel unsafe. Safe Home Act. This provides victims of domestic violence, dating violence, stalking, and sexual violence to flee existing dangerous rental housing. So before today, if I had asked you, can somebody break a lease? If you didn't know the answer was, well, it depends. Here's the well, it depends answer. Okay? But this is what kind of housing is covered here? Well, private Section 8 project buildings, but not public housing under the Safe Home Act. What does it cover? Victims of domestic violence may break a lease if there is a credible threat of imminent danger for future harm. Harm that was going to occur at the premise, not at work, but at the premise. The victim is allowed to provide the landlord with a 3-day written notice of fear before or after vacating the premise. They can vacate the premise. What do they have to do? Provide you notice that that's what's happened. Okay? No further proof is needed in this situation. This is domestic violence. If it's a sexual assault, it's a little different. There's no credible threat imminent necessary, okay? But the 3-day notice should be filed within 90 days. Third-party proof is required here, though. Okay. What about the right to lease, to terminate the lease? Okay, sexual violence victims do not need to show credible threat if the assault took place on the premise. If, and this, a lot of these laws are because somebody tried to do something that wasn't that common sense. So we have this here. If a landlord sues for the rent, you've just tried to sue for rent for somebody who's a victim of domestic violence. Okay, the victim, it has been shown, the victim has available to them an affirmative defense. All right? So think twice before engaging in this. All right? We want the victims to feel safe. We want victims to be protected. Emergency lock changes. If written lease or abuser are not on the lease, the request must be from the tenants. Yes, your tenant can request that the locks be changed. What must be done? Well, it must be, the request must be from all tenants on the lease. That request must be in writing due to a credible threat. There also must be provide one source of evidence. Okay? Medical, court, police report, statement from an employee, something of that nature. But they can request that the locks be changed. Again, if somebody comes to you and says, hey, I'm part of I feel that there's an unsafe situation, I want my locks changed. If you do not take action, okay, you can be responsible. You want me to back up on that one? Okay. You can put yourself into a legal lawsuit. So, because you're probably going to request these slides from me, take my card, say, Jeff, I want these slides, email them to me, I will. What you should do when somebody comes to you and says, hey, I want my lock changed, you should be thinking, well, wait a minute, Jeff told me something about a lock change. Do I or do I not have to do this? And the answer should be immediately, yes, I do. What are the requirements? Go look at this again. All right. Here's the issue, though, that comes up, though. Landlord must change the locks within 48 hours of being given notice. If the landlord does not respond, the tenant may change the locks, but the tenant is responsible for the lock change. The cost of the lock change. Forcible Entry and Detainer Act, basically the eviction, okay? Victim has an affirmative defense if the eviction case, in an eviction case, if the eviction is based on the victim's status as a victim of domestic or sexual assault. How does this come about? Okay, here I am, I'm the bad guy, my significant other who I've just have, there's been a sexual assault or a battery on this, my significant other, okay? My significant other files a police report. Well, now we're into that crime-free lease addendum aspect. Hey, there's been a crime on the premise, can the landlord evict somebody? Yeah, but you know what? I'm on the lease. You can't, I'm protected. You can't evict me for being a victim. And that's what was so much of a concern previously. We did not want victims to become victims again. You can't evict somebody who's been someone who's been part of a criminal assault, sexual assault. Goes on that there's, yes, sir.
If both people are on the lease, can you evict one person?
There's something, depending on how it is, you can bifurcate the lease. You don't necessarily want to evict that other person, but there's nothing that would stop you from renewing that lease or issuing a new lease, right, with that one person. But the problem, though, too, is you just said the word evict. You do not want to go after the victim of a crime, a sexual assault or domestic violence.
Not go after the victim, but the perpetrator.
I understand, but if they're both on the lease and you're going through the process of eviction, there is one specific thing in here that I was going to show you, that I will show you, that talks about the bifurcation. But it's somewhat narrow, all right? Landlord can overcome the affirmative defense that the victim has raised if he or she can show that the tenant's continued occupancy would pose a threat. Okay, so that person is on your property. Is the bad guy coming and causing a disturbance? Is the bad guy bringing the rest of his family there, his friends? Is there a possibility that there is going to be additional threat to your other tenants? Well, that's an affirmative defense for you. But again, tread lightly on this. Contact that attorney. Anytime you get into these situations, especially when there's somebody who's a victim of a sexual assault, domestic violence, get in touch with that attorney before you start to proceed. Landlord can evict the abuser only. Okay? Landlord has a right to bar an individual not in the household. Notice of the tenant, notices the barred individuals. There is something called the Violence Against Women Act, and this is that bifurcation I was talking about. The purpose is provide protections of domestic violence, dating violence, sexual assault, but it's covered under specific housing. Ours would be the housing choice vouchers. And here, you cannot deny an application. Somebody comes to you and says, hey, I've been a victim of a domestic violence, sexual assault. This is one of those protected classes for the vouchers. You can't deny them. Okay? What about the termination? Well, you can terminate cannot terminate based on the fact that she is a survivor, the crime is directly related to the abuser, or the incident is actual or threatened violence does not constitute a serious threat. When can you proceed? Well, you can proceed if the lease violation is not based on the acts of the violence. There's violations that are not related to that issue. The housing authority owner can demonstrate an actual and imminent threat. Again, similar to the other one. The threat that we're talking about is real. It can't be imaginary, it can't be made up, would occur within immediate time frame, and can result in serious bodily harm. This lease, this is a bifurcation I was talking about. You can bifurcate to evict the perpetrator specifically in this one. There are proofs that are required. The owners can take the tenant's word that they are a victim. They can request proof that must be written. Tenant has 14 days or any extension granted to them. The proof that you can be back is that, hey, here's a certification form from HUD. I've got police reports. I've got some legal documents. I've got a third-party signature. Okay? This is all legal issues, and I strongly, strongly recommend, if you have not heard me yet on this, this is where you really need to contact the attorney before proceeding. Victims have rights. You do not want to violate those rights when you start to get towards an eviction process. And this is rightly so. We should not be, again, we should not be making victims out of victims. All right. There are two different people you can contact, Legal Assistance Foundation, Metropolitan Chicago, or the Shriver Center, who are located nearby. Any questions on this? Okay, if you stick with me for 3 more minutes, I think, we'll get you out of here. We do want to make you aware that there's a smoke-free housing program available to you. Believe it or not, tenants are looking for properties that are smoke-free. Can you make your property smoke-free? Yes, you can. How do you go about that? Well, this is how you're going to be able to do that, okay? What does a smoke-free building entail? It means that you cannot smoke on the property, in that unit, or in the common areas. You can smoke what? Within 10 feet of the property, I believe it is. Okay? Pardon? 15? Okay. I'm sorry? Well, okay. This is a opportunity for you to have rental property that you deem is smoke-free, meaning nobody can smoke. Pardon? No. No, you're protected, and this is what we're showing you here, okay? That property managers' conversation, you're empowered by federal and law to make this, you have a right, this is where you, the landlord, have rights now. Yes, you have a right to have a smoke-free property, but you just can't go about it willy-nilly. You've got to have a procedure. This is that procedure, okay? Let's just talk about the obvious, though, first, before we go into the procedure. Why would you want to do smoke-free? Well, contact your insurance company. You may find out it's beneficial to have a smoke-free building. On top of it, it's going to be possible for you to get renters who want smoke-free buildings. They're in demand now. It's going to cause you less when the tenants move out for cleanup. Okay? I'm old enough to remember when there was smoking on airlines and other locations, and you'd look up and you'd see the yellow stains everywhere. Okay? That's still going to happen on your property. This will allow you to have cleaner property, have it turned over quicker, not as much to do when you're changing it over. Okay? We in the village would like to have at least 5 to 10 smoke-free properties by June 30th. I'm not in the health department. I don't know what that number is right now. All right. What do you have to do? This is to answer your question. One, you have to survey the existing residents. Tell them, look, I'm going to be making my property smoke-free. Well, what's your time frame? Well, my time frame realistically might be 3 months. Okay? I am going to be making my property smoke-free within 3 months. From then on, what I would do is put this into your lease that your property is smoke-free. Okay? Can you, if it's not, can you change it right now? Yes, you can. You can change the property so that it does become smoke-free. You are empowered to do that. Okay? But you have to allow people notice, you have to provide them a timeline, and then you're going to amend all the leases as you move forward. If you have any further questions, I do suggest you contact our Oak Park Health Department at this number, 708-358-5484. They will give you a packet, and they will present you with the material you need to move forward on this. Again, I think that it could be seen as desirable. Okay. All right. Yes?
I don't know what the laws are, but does smoke-free also mean marijuana? I don't know I really don't know what the laws are.
708-358-5484. No, medical marijuana could, that's going to be one of those, I think, ask them. Now, I have to ask, are there any other questions? No, yes, sir.
No.
Okay, see me otherwise, see me after. You've been most gracious. I do appreciate the time that you've put here. Hopefully you found it well spent. If you've got any questions, please take my card. Don't forget to sign the attendance, because we will be now making sure that you attend these on a yearly basis. Thank you very much.